So hi everybody, you're very welcome back to Law Hero, and today we're talking about one of my favourite subjects, which is competition law. So competition law basically is how suppliers of goods and services compete, quite simply. There's a lot more to it than that. It wasn't always a thing. So in Europe, we've only had it since the 1950s, since we had the the establishment of the Coal and Steel Pact, rather, with the basic 6 countries that started the EU. Then we had the European Community, and since then, that's when we've really had competition law in the EU. But before that, there was really just there was a restraint of trade, common law rule. You shouldn't restrain trade, but it was quite frankly a free-for-all. And the origin of competition law was actually antitrust law in the US, where certain companies in the US were getting so big that it was going out of control, so that the law had to intervene to somehow control what was happening between these enterprises. Indeed, if you read the book Post-Corona by Scott Galloway, he's a professor in New York. He basically says that competition law in this day and age has not caught up to the monopolies that Facebook and Google have over information. The law isn't sophisticated enough to keep up with their monopoly of data, because it was never really envisaged that data would become a commodity the way it has done now. And I think it's up to lawmakers to try and control, because basically these like Google and Samsung with the iOS, and then Apple, with their Google Play, and then the iOS systems, and then you have like YouTube and Instagram, and you have such massive amounts of information. I mean, you only have to look at the data centers to understand the volumes of information these companies have. This completely gone out of control, but I digress. We're really kind of focusing on tangible goods and services when we talk about competition law in the traditional sense. So basically, the whole rationale behind competition law is the protection of consumers, but also ensuring free trade. And basically, a competition law is any law or regulation that promotes or seeks to maintain competition and prohibit anti-competitive behaviour. So when it comes to the protection of consumers and ensuring free trade, we basically want to ensure that we're not inhibiting commercial economic activity, and we're making sure that it is consumers that are not paying for there to be freedom of trade. So sometimes you'll hear like of a monopoly, and that is one company who has exclusive ownership of a large part of a market, like making it impossible for smaller players to compete. And why this is damaging for everybody, like worldwide, is because there's a misapplication of economic resources, and this reduces consumer choice. So what I will do in another video is I will talk about game theory, because basically when you only have one choice, this is what fuels a monopoly. A monopoly, somebody who's acting in a dominant fashion. If you think about the United Brands case, which I'm sure you guys would have learned in Article 102 TFU, they monopolized every part of the distribution of bananas. So like from the ripening to the transportation to the distribution, like to the retail distribution, that is monopolizing banana trade. And it is impossible for smaller businesses to compete with them, because of their economies of scale are so large, they can afford to sell the bananas cheaper. So like they're winning at every point of the distribution. Now, you will see from the way I'm speaking that competition law is very much an economic topic. It's based around economics. You need economists to decide what is the market, what are the choices, what are the freedom to trade. These are all economic decisions. That's why it's very, very difficult for lawyers sometimes to grapple with the competition law topic, because it is economic analysis that is done, not necessarily legal. So when it comes to competition law, like usually when you're studying competition law, you have like Article 101, which is horizontal agreements. So horizontal are businesses that are on the same level of the supply chain. Vertical agreements are distributor supplier. So they're your Article 101, your like cartel law, you would call it. And then there's like Article 102 TFEU. By the way, this is Section 4 and Section 5 of the Competition Act 2002 as amended 2017 or whatever it was. And that is like your abusive dominance or your monopoly. And then you have merger control, which I think is like Article 106 TFEU, or maybe that's state aid. I can't remember, but merger control is more procedural. It's more a factor you have to put into your agreements when you're doing a merger, because you need competition law clearance from your own jurisdiction, which in Ireland is the CCPC, or if so cross-jurisdictional, you will need European Commission clearance. Also, depending on the thresholds of your turnover, that will dictate the procedure for the merger control. So I'm gonna quickly go down through, so horizontal agreements or cartels, and what I always think for horizontal agreements, like these are parties on the same level of the supply chain. So for example, you have like heating oil distributor, and then you have like all like the local heating oil companies. So we'll say if you have a heating oil company in Cork, heating oil company in Tipperary, they're getting their fuel from the same source, they would be horizontally aligned. And if they colluded with each other, as in this lad says, hey, I won't sell to your customers in Cork, the Tipperary lad says, I won't sell to your customers in Cork if you leave me alone, and we kind of agree between us, we're going to carve up the market between us. That is illegal, because they are competitors, they're interacting, and they're essentially allocating customers to themselves. But that could also be like if they fix the price of the oil between them. This actually happened, by the way. It's called the heating oil cartel. Or if there was a tender and they bid rigged, for example, they are exchanging information between each other, which is confidential. They could also do this indirectly via a trade association, and this happened, for example, with LCD screens. Everybody has LCD screen on their television. A few years ago, you had like a lot of the Eastern, so say like Chinese, Japanese electronics companies coming together and actually setting the price for LCD screens, which was passed on to the consumer, which is illegal because they're on the same level. And they could also restrain trade in other ways. For example, those two competitors could boycott the distributor, which is unfair because they've gotten together, they're on the same level, they're sharing confidential information. Vertical restraints then, so for example, if you think a distributor would be like Apple are create and design Apple products, and then we'll say the retailer would be like Harvey Norman, for example. Or if there was some prohibitive way that Harvey Norman had to sell. For example, if Apple said to Harvey Norman, you know, if somebody comes into the shop and if you don't offer them Apple products first, then we're going to, I don't know, like blackmail you or something. Like it's just like really like overt control of the retailer. That would be considered like hardcore restrictions around trade. The next one is like Article 102 TFEU, which is like monopolies or abuse of a dominant position. So bear in mind, they say abuse of a dominant position. Being dominant per se is not illegal, but the impetus of the regulation is to like control the big companies. Market share like is seen as being dominant usually if it's 30%, but it's on a case-by-case basis. And then I guess the next question is, what makes you dominant? And as I said, in the United Brands case, it's like if you have unfair purchasing power, if you have the ability to limit production based on your own needs, or if you have some like technical know-how that nobody else has, that kind of way. That is all kind of hallmarks of dominance. The next question then around dominance is like, how do you define a market? Because obviously you're dominant in a certain market, and the question around like to ascertain what the relevant market is, they use, or the economists use a test called the SSNIP, which is the cross price elasticity in relation to close substitute for the product or service in question. So for example, could you show that a small change in the price of bananas would result in the consumer switching in a significant degree to apples? So therefore, because bananas and apples are fruit, you would say that the relevant market is fruit rather than bananas, because they're able to switch fruit. And the problem with actually the United Brands decision, and the reason why it got such a backlash by lawyers, was because the judges argued that bananas are in a league of their own. And there's like a very famous quote that says like, bananas, because of their seedlessness and easy handling and loved by older people and babies, like make it a very unique fruit, and basically there is no replacement for a banana, the judges said, which I find very interesting. Whereas like basically they're implicitly arguing that you could swap out an apple for a pear, as in apples aren't in a market of their own. But I would argue apples are in a market of their own, because, well, then on that basis every fruit's in a market of its own. Like, could you swap plums for pears? Could you swap strawberries for grapes? Like, it's on a case-by-case common sense basis. But the judges in that case argued that bananas were in a league of their own, and a lot of people didn't like that because they said it would be like a floodgate argument, which I agree with to an extent. I'm not really going to go through merger control. It has come up actually on the FE1s a good bit around the white paper and merger control. But yeah, I mean, merger control ultimately is to like ensure that there is like healthy competition, that one player doesn't get so big that they become dominant and then abuse that dominant position. That is a quick sum up of competition law. I hope you enjoyed it. I love doing these videos, and if you have any questions around competition law on the FE1, please drop me a message and I'll see you all in the next one.